concerted effort in Philadelphia to not use the language of slave, of slavery. Why? When you say something in writing, you acknowledge it exists. Writing's very powerful. When you have the Declaration of Independence that speaks of all men be created equal, those are words which everyone can read. It's there in black and white. And people read that and said, okay, what about us? Why aren't we equal? But the opposite's also true. When you have a document like a Constitution that speaks of slavery, it's there for all to see and acknowledges that, in fact, slavery can exist under the Constitution. For the Constitution to say they're slaves means that there can be slavery in the Constitution. The framers, again in a series of compromises, would not use the word slaves. They would not use the word slavery. They would not. All they would say is such persons, other persons. And it didn't refer to the slave trade, which is what it was known as. They said the migration or importation. That's a funny phrase. Think of like, importing goods, like bananas or like coffee, right? A commodity. But also migration, people who move. So the migration and importation of such persons as any of the states now existing shall think proper to admit should not be prohibited by the Congress prior to the year 1808, but a tax can be imposed on each person not exceeding $10. So what does that mean? We're kicking the can down the road for 20 years. Right? The Constitution was approved in 1788 or 1787. They said for 20 years we will not affect the slave trade. That the states that want it can have it, and Congress cannot limit them. This is unusual. Usually federal power is supreme over state power, right? The federal Congress can pass a law saying we ban the importation of slaves, and that's a federal law that preempts a state law, right? But not here. The Constitution says you cannot ban this. And in fact, if you read on, you could not even have a constitutional amendment about the slave trade till 1808. Imagine that, a constitutional amendment that's unconstitutional, right? It's actually a sort of a quirk, right? Can Congress limit their own power to pass an amendment? So it's actually an unknown question. We don't have an answer to it. But Congress could impose a tax on such people. This one actually worked out. Between 1788 and 1808, the slave trade became extremely unpopular. This was a barbaric practice. You ever see the photograph or the drawings and the sketching of people stacked on the boats? It's gruesome. It's gruesome. People kidnapped in Africa, sent across the ocean, and basically sold into bondage. If you go to New Orleans, other cities, they have these auctions, these markets, these places where they have sold as if they were cattle. If you go to Charleston, you'll see it there as well. But this was considered a barbaric practice. And in 1807, Congress passed a bill banning the slave trade on January 1st of 1808. So the very first day in which this practice could be banned, it was in fact criminalized. And who signed that bill? President Thomas Jefferson, who was a slaveholder, among other things. So even, what I'm trying to get to is, even those who had slaves still saw this practice as something that had to be ended. And even before that, James Madison, again a slaveholder, proposed taxes on the importation of slaves. I think it was $1 per head. Congress passed bills banning using shipyards to build the boats used for the slave trade. Even Congress tried to get around it. So this is, again, one of the compromises where things sort of worked out. But again, when the Constitution was written, people expected slavery to slowly fade away. And they said, okay, if we stop importing new slaves and we don't have much of a need for slaves, this will just eventually fade away. Okay. But in 1793, something happened. There was an invention a very important invention, which maybe you never thought much about, which was the cotton gin by Eli Whitney. Everyone ever learn about this in school? Cotton is a very hard crop to work with. It these very thick seeds you cut yourself. The cotton gin, imagine you take a comb or a brush and you pull through the cotton. You can pull out the cotton seeds very easily and make it very easy to turn into clothes and garments. Before the Constitution was ratified, the primary crop was tobacco. And people thought this was not going to be able to sustain an entire economy. But indeed, as they say, cotton became king. And this device, this invention, created a much greater demand for slaves to operate and pick the cotton and use it to create goods. So even though at the time the Constitution was written, this was sort of fading away, things changed pretty radically in the years afterwards, that now there would be a need, okay, we're not importing these people, but we will keep them in bondage. All right? Now, I've gone through two of the clauses of the Constitution that could be called compromises. The third one is only a compromise, perhaps in a limited sense, and this is the Fugitive Slave Clause. And we already talked about this when we studied Prigg versus Pennsylvania. But I want to give it a little more background to understand why this was so significant. There was a very famous case from 1772, it was an English case, called Somerset's case. Somerset case, Somerset. TT, so there are two T's. It was an English case by Lord Mansfield, and the facts were like this. England had a big empire around the world. Slavery was already banned in England, but slavery was permitted in the various colonies owned by England, America among others. And there was a Brit who brought his slave from a colony where slavery is allowed to England. It was actually from Jamaica, as it were. Right? There was a slave owned in Jamaica where slavery was allowed, and the slave was brought to England. And at that point, the slave asserted, aha, I am on English soil. I'm free. And the court accepted that argument. And what the court held is actually very important. The court said that slavery is not some sort of natural state of being. Slavery can be supported by what's called positive law, by statutes. In other words, the government must approve the ownership of slaves. In England, slavery was abolished. So when you brought a slave to a place where slavery did not exist as an institution, the bond disappears. And it was said that bringing a slave to free soil, to breathe the free air of England, as it were, the person became free. Again, that was 1772, a couple years before independence, and about 15 years before the Constitution was written. The framers were acutely aware of Somerset. They knew about this case. And they also knew what would happen if, let's say, a slave from South Carolina travels up to Pennsylvania, where slavery has been abolished. The slave would become emancipated, perhaps, under the Somerset principle. So the framers of the Constitution knew about this, and they had to deal with it. Again, you say, well, this is, why would you make a deal with the devil, to quote Garrison, right? Why would you make a deal with slaveholders? If they didn't figure this part out, there would be no Constitution. There'd be no country. There would be no 14th Amendment. Like we would probably have different scattered republics. More likely than not, the English or the Spanish would have taken us over because we've been weak and we couldn't fight against them. Independence would have lasted a decade. We'd be speaking Spanish right now, maybe, or something else. I'm only slightly exaggerating, but there was no guarantee our nation would survive divided. Just it wouldn't have happened. I don't think it would have. We would have. I mean, even as it was, we were invaded by the British, we were invaded by the French, all over the place. We had wars with Mexico. So they made this compromise. And this is the clause that we talked about in Prigg. And it says, no person held to service or labor in one state, under the laws thereof, escaping into another, shall, in consequence of any law or regulation therein, be discharged from such service or labor, but shall be delivered upon claim of the party to whom such service or labor may be due. So first off, again, it doesn't say the word slavery. It says no person. And that's actually significant, right? Person, there are people, right? There's a humanization element there. Held to service or labor. That is the closest you get talking about slavery, right? You had different categories. People called indentured servants. So you ever heard this phrase? There's a person who basically committed to work for a certain number of years and they would be freed, and it was pay off a debt usually. But it doesn't say what kind of labor. Service or labor in one state under the laws thereof. Why is that important? Because slavery exists only as a facet of law. Right? That's the principle of Somerset. That if a state does not allow slavery, slavery does not exist. It's under the laws of that state. It's not under the federal constitution you're a slave, it's under the state's laws. And then escapes into another state shall not be discharged from service. So again, it's kind of complicated because there's no there, but if one state allows slavery, but the laws of another state say there's no slavery, the person cannot be discharged from service. Again, if the laws of one state allow slavery, but the laws of the other state do not, the person cannot be discharged from slavery because of the second state's laws. They expressly anticipated Somerset, and they said, we are not going to be bound by Somerset. Instead, they should be delivered on the claim of the party to whom such labor is due, the master. And this gave rise to the Fugitive Slave Act. There were a couple of them, and they created these very draconian methods where people could actually go from state to state capturing people. And by the way, a lot of these were just not true. They were just making it bogus. Like, oh yeah, he's a runaway slave, and there was no like fingerprints. There's no to verify. How did you know this was the right person back then? A lot of false claims were made. People were sold downriver, as it would say. So again, the first two of these were very significant, but the last one was a compromise in only the slightest sense. This was a giveaway to the South, but essential to have ratified the Constitution. All right, questions so far? Questions so far? Yes, sir.
So in the fugitive slave clause, that's not the authority for the person to go back to get the person back from the free state.
Well, that was the issue in Prigg, wasn't it? I mean, what clause actually supports the Fugitive Slave Act? It was argued by Chief Justice Chase that there is no such authority, but if you read Chief Justice Story in Prigg, he says it's really the necessary and proper clause. But putting aside the Fugitive Slave Act, the clause itself was to negate the Somerset principle. That's the important point for today's class, right? To say that we will not follow the Somerset principle. That if you step foot on free soil under the Constitution, you're not free. Okay. But let me ask you a question. Could a state follow Somerset? Yeah. Right? What if Missouri, for example, said, you know what? We allow slavery, but we will follow the Somerset rule. That is, if a slave in Missouri travels to what's called Illinois or Wisconsin or Minnesota, and that slave touches free air, then we will recognize the claim of emancipation. This clause only operates when there's a conflict between the laws of one state and the laws of another. But if both states basically follow the emancipation principle from Somerset, that'd be all right. And in fact, that's what Missouri law provided. We'll get there in a moment. But under the traditional rule of Missouri, a slave who escaped to another state would become free. You would recognize Missouri's law. Missouri changed that. Right? That was the Missouri Supreme Court's decision to change their precedent. But the precedent was in Missouri was actually the Somerset rule. Everyone see that? All right, questions so far? All right, good. So when we're dealing with these three clauses, we're speaking about a euphemism. We're not going to be talking about slaves. But there was another clause that was very relevant also, which I want to talk about for a moment. It's in Article 4. Where is it? Do I not have it? Yeah, here it is. Sorry, I passed it. Article 4, Section 2. This is this doesn't have much salience today, but was very important in the 1800s. It says, the citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. So the wording is a bit weird, but I'll break it down for you think cleanly. What are privileges and immunities? These are certain rights. Maybe the right to speech, the right to religion, maybe the right to bear arms, maybe the right to own property, the right to serve in a jury. There are different people who disagree, but these are a bundle of sticks, if you will, a bundle of rights. What does this mean? If I'm a citizen of New York and I travel to New Jersey, what rights do I have? I have the same rights that a citizen of New Jersey would have. In other words, New Jersey can't treat me any worse than they treat their own citizens. Pretty much, right? New Jersey must give me, as a traveling citizen, the rights that other New Jersey citizens might have. Right? I can't bring my New York rights to New Jersey. That would not be correct. But whatever privileges and immunities New Jersey gives its own citizens, a citizen from New York traveling to New Jersey gets those rights. Everyone with me so far? So let's just make the facts a little bit different. Let's say that there was a free black person in New York, right? And they had them. They existed. They voted. They had all the rights and privileges. And a free black person from New York travels in a boat to South Carolina. And he shows up in South Carolina. He says, hello, South Carolina. I'm a citizen of New York. I am now in South Carolina. I want all the citizens that you give to South Carolinians. And what do you think South Carolina said? You are not a citizen. But wait a minute. I am. Look, my papers. I'm a citizen of New York. I can vote. I have all the rights in New York. You have to treat me as a citizen. This was a source of national controversy. Long before Dred Scott, my friends. Because if you were a citizen, you got all these rights when you traveled abroad to another state. Could you be a citizen of a state if you're of African descent? Now Dred Scott's starting to come to the picture, isn't it? This wasn't some new controversy. This happened all the time, by the way, where sailors, happened a lot with seamen, sailors, who would travel from the north down to the south for commerce, for trade, whatever else, were basically arrested. If they basically would arrest free blacks, put them in jail, saying, you're not a citizen, we're going to arrest you, deny you all these rights. What else? If you read Dred Scott, what does Roger Taney say? He says, black people can't be citizens. Why? Because they get all these privileges and immunities. And would we really have it that a traveling person from New York can go to South Carolina with a rifle to bear arms? Could that really be the answer? He finds it so preposterous that free blacks could have rights in other states. He says they can't be citizens. Like, he actually rejects he says, can they really have free speech rights? That can't be right. Could they have the right to bear arms? That can't be right. So he uses this clause, which you probably never heard of before this class, as a basis that they cannot be citizens. But this raises a fundamental question. What is a citizen? What is a citizen? Does the Constitution define citizenship? Not before the 14th Amendment. Did not. You can read it cover to cover. I've done it myself. There are references to citizenship, for example. It says, if you want to be president, you have to be a natural-born citizen. Okay, there's that. If you want to be a member of Congress, you have to be a citizen for, I think, 9 years, and a member of the House, 7 years. There are references to citizenship. It says if you're a citizen of the states, you get all these privileges and immunities. It also says Congress has the power over naturalization. But the original Constitution was sort of silent. Silent about citizenship. Just didn't really say very much about it. Yet citizenship was so important because it came with these rights, these privileges and immunities. Let's go beyond citizenship, right? Let's go to the Fifth Amendment. no person, not citizen, no person, shall be deprived of life, liberty, or property without due process of law. Would a federal slave act, right, the fugitive slave clause, a fugitive slave act, deprive a person of liberty without due process of law? I would say so. So there are all these sort of tensions and inconsistencies in the 1800s. I'll give you one more. Look at the map. The map of the United States. All right? I'm sure you've seen a map of the United States a million times, but you never really focus on this white line. See this one over here? And see, you have all the states kind of borders kind of around that line. There's Virginia, there's Kentucky, there's Tennessee, Missouri, Arkansas, and then kind of Oklahoma-ish, and then the Texas Panhandle, right? You ever notice about the little panhandles there? Yeah. Why is that line there? 36, there was 3630. Yeah. So this was what's called the Missouri Compromise. It was 1820. Might be off in the year. I think it's 1820. And this was a compromise that Congress reached. And they reached this compromise for very deliberate reasons. Why? Everyone saw a conflict was coming. With each new state that was admitted, there was a choice. Would it be a free territory or would it be free soil or slave soil? Right, we have free state or a slave state. Why did this matter? With each new state admitted, you'd have members of Congress. You'd have 2 new senators and members of the House. And every time you added new slave states, those would be senators and representatives who would probably favor slavery in the Congress. And if you admitted a free soil state, those would be members of Congress who would favor the abolition, or at least the ending of slavery. So Congress said, fine, we'll make a compromise. If you're north, by the way, this map is not to scale, I swear. Texas is much bigger than Minnesota. Don't even get me started on this map, right? It's just like squished in the wrong way. But if you were north of that line and you were a new state, you would be admitted as a free soil state. And if you're south of this line, you'd be a slave state. But it's actually more than that. It wasn't just about the state, it was about the territory. When I say territory, these were not admitted to statehood yet. So you had the what's called the Northwest Territories. And modern day Minnesota was part of these territories. And these were territories governed by federal law. And federal law says there's no slavery allowed in these territories. So what was being argued at the time? Dred Scott didn't come out of nowhere, right? Roger Taney used arguments that have been around for many years. This is one thing I want you to appreciate. People want to cancel Taney, fine, but there are a lot of other people we have to cancel as well. It was argued in a series of reports in the House that Congress could not ban slavery in the territories. What? Well, let's look at this. So we know, maybe you don't know, but you should know that Article 4, Section 3 says that Congress shall have power to dispose of and make all rules and regulations respecting the territory or other property belonging to the United States. It was argued at the time that this clause, and I swear this isn't Dred's, I don't make you read this part of the case, but it's in there, I promise you. That this clause, which gives Congress power over the territories, only applies to territories that were belonging to the United States. Past tense. Belonging when? Before the Constitution was written. In other words, if there was a territory owned by the United States before the Constitution was written, Congress can regulate it. I swear this is in there. I promise you it's in there. But if there's a newly acquired territory that did not belong to the United States when the Constitution was adopted, they don't have the power. So it's argued Congress cannot ban slavery of the newly acquired territories. This is actually in Dred Scott. It's a long opinion. I gave you only a small snippet. You think reading was long? The thing's like 200 pages. Okay, that's number one. But number two, it was argued that eliminating slave rights in the territories was unconstitutional. Wait, what? So remember I said a minute ago, we have the Fifth Amendment due process clause, right? If you have a law that authorizes slavery, that would seem in my mind to deprive you of your liberty with that due process law. Wouldn't you just say that's maybe just a guess, right? But slaveholders flipped that argument around 180 degrees. They said, no. It's not the slave who has a claim. It's the owner who has a claim. Because if I bring my slave to a territory and that slave is then emancipated, the government deprived me of my property with that due process of law. I said again, if a slave owner brings a slave to a federal territory and the federal territory says you cannot have slaves, this person's now emancipated, the slaveholder had his property rights violated in violation of the Fifth Amendment. Roger Twain did not make this up. This has been an idea around for decades. You say, wait a minute, Josh. All this text says is that, if they deprive you of your property, you have to get due process, right? Isn't there some sort of trial or procedure? No, they argued more. They argued that this act protects a property right in slaves. They said this provision, the Fifth Amendment, about liberty, protects a property interest in slaves that the government cannot deprive you of under any circumstances. Now, I'm going to give you a term. You'll write down your notes. You understand it for now. You'll get it later. Substantive due process. This is a term that didn't even exist in the 20th century, but it's what Tani was writing about. Substantive due process. Well, it's like an oxymoron, as Scalia would say. Right? How can procedure be substantive, right? Didn't you learn about incipient procedure and substance difference? Yeah, well, welcome to common law, right? Nothing makes sense. Substantive due process is this concept that the Fifth Amendment protects a right to some property. And the government cannot take this away from you. By the way, this became very controversial. In the early 20th century, you had judges saying, that if you have a right to property, that means the government can't regulate your business. Substantive due process. The 1960s and 70s said, if you have a right to your own body, they can't regulate birth control, they can't regulate abortion. They can't regulate your sexual relations. There's a right to gay marriage because of the due process clause. So there's a thread, which we don't like talking about, between Dred Scott and Roe v. Wade. People don't like talking about it, but it's there. The doctrine of substantive due process was more or less established by the court in Dred Scott. The idea that slaveholders have a property right to their slave developed this notion. Tawney did not invent it, I'll be very clear. People were writing about that years earlier. But this idea of substantive due process started to emerge. Yes, sir.
So are those two arguments just only in response to the Missouri Compromise, or I imagine it went much more broader?
It had to do with the District of Columbia also. There was a vigorous debate, could you ban slavery in the District of Columbia? And a lot of people said you could not even ban it there because it was a federal territory and that there was no power to do it. Yes, Stephen?
So I thought the Missouri Compromise, the 1821, was only for new states and not talking about territories. Is that wrong?
Well, right, but there was also laws governing the territories as well. Right, so Missouri Compromise was about states, but there were federal laws governing the Northwest Territories and governing the other territories out west. But you were correct. Any other questions so far? So then, you had on the one side people, mostly Southerners, but not only, arguing that the Missouri Compromise was unconstitutional. You had Southerners arguing that people of African descent could never be citizens, even if their state granted them citizenship. What about the other side? Right, we only talk about one side, but there's actually another side. This is one area where Randy and I, our book is, I think, distinct. I think we do try to explain there were other thinkers at the time who perhaps saw things a bit differently. We give you some reading on this. These are the abolitionists. Now, when you think of abolitionists, you think of Harry Tubman, people tried to, free the slaves. Yes, but there also were writers and thinkers who argued against it. We already talked about Salmon Chase, the Chief Justice. Earlier in his career, he argued vigorously that the Fugitive Slave Act was unconstitutional. And he was an abolitionist, no doubt. He favored the abolition of slavery. But he made legal arguments based on the Constitution. That is, there is no enumerated power to justify this law, right? The necessary and proper clause doesn't stretch quite that far. But there are other abolitionists. I gave you Frederick Douglass, we'll talk about him maybe a little bit later, who argued different things. One of them, his name was Garrison, William Lloyd Garrison. Very important historical figure. Garrison argued that the Constitution was a deal with the devil. He was very vigorous in this front. And he argued that by making this pact with the Southerners, the slaveholders, the Constitution itself was flawed. He argued vigorously the Constitution did approve slavery. In some regards, he's actually agreeing with Judge Tawney in many ways. So it's actually this point that Douglass makes in his writings, that the Garrisonians actually agreed with Tawney about what the Constitution says. They have other people, Frederick Douglass among others. Douglass was a remarkable human being, just one of the most important Americans you've ever heard of. Who ever heard of Frederick Douglass? Just curious. Heard of him? Good. He was born a slave, and he was only educated later in life. He escaped. He fled to England. His freedom was purchased. But he gave a series of speeches, which I had you read some of them, one of which was in New York, the other was in Scotland, where he argues quite vigorously that the Constitution was not a pro-slavery document. And he distinguishes between the intentions of those who framed it and the meaning of the words they chose. He basically says, look, we can stipulate that some of these people probably had ideas about slavery that were not what I would like to have, but they didn't put those into writing. They chose words to not go there. And Douglass says when you pick words, when you use language, that has an effect. That has a meaning. Because you lock people in. And we're not trying to figure out what was in their heads, figure out what the words they meant were. And this is sort of a broader debate of what you might call originalism, right? Do we focus on the intentions of the framers? We focus on the meaning of the words they chose. And most originalists today would say, no, we focus on the meaning of the words they chose. Right? The intentions are hard to figure out. This person thought this, and this person thought that. We don't know how to reconcile these, but they all chose words. We focus on the meaning of those words. So leading up to Dred Scott in the 1840s, in the 1850s, there were these vigorous debates between the abolitionists who argued that no, the Constitution does not support slavery, and the people in the Roger Tawney camp who said, yes, it does. And this all came to a head with the Dred Scott case. Yes?
Is that the same as like a textualist?
Oh, what a good question. So, textualism is a broad school of thought. But textualism refers to trying to understand the meaning of the words that were chosen. Originalism is a subset of that. With a document drafted today, we can figure out what words mean today. But sometimes meaning changes over time. It drifts. So originalism asks, what was the meaning of something at the time it was enacted? We're sort of looking back, and we can find many ways of determining that original meaning. It's a topic for an entire class if I could, but I'm glad that you asked. But what's just remarkable about Douglass, to your question, is that Douglass understood these concepts. He was not trained as a lawyer. Again, this person who grew up a slave, and he writes such brilliant, eloquent things. With that legal training, it's just remarkable. So he understood these concepts intrinsically, and I think he got things mostly right. A good friend of mine is writing a book about him now. Just the stuff he's finding is just fascinating. Brad Ribiera, BYU, really brilliant scholar. Yeah, really nice guy too. You know him?
No.
He's a really good guy. Okay. What else before we get started? So, who here knew that Dred Scott was about diversity jurisdiction? Did anyone know this? But it matters, right? I tell you, CivPro, right, that's all cool. It comes from here. This is where it actually matters. So we got the Constitution, right? Article 3, diversity jurisdiction. And it says, where is it? The judicial power shall extend to controversies between citizens of different states. Seems simple, right? Not so fast. This entire case was about diversity of jurisdiction. Let me put the easy part at the beginning. Let me start calling. I haven't got a cold name in an hour. Who? Do you remember where we are? You remember from 2 weeks ago? I'm sorry. Okay. So, Angelica, I'll give you an easy question if I can, please. So, in CivPro, right? If you have a case in which the court lacks jurisdiction, that is, let's say I sue you, we're both Texas citizens in federal court, and we have no diversity. What happens to that case? Does the court opine on the merits of the case? Does the court explain why my claim is good or bad? So then why the heck, Angelica, was this not a one-page decision saying dismissed for lack of subject matter jurisdiction? Louder?
Because it had to deal with slavery. I think it was.
He wanted to decide things, didn't he?
Yes.
If I could draw another analogy, Marbury, right? Wasn't the holding of Marbury the court lacked jurisdiction to enforce the remedy, to issue the writ of mandamus against the executive branch? Yet you had to read this long opinion, didn't you? Huh, why? Another one, Obamacare. The court ultimately ruled that it was a tax, right? Or sort of like a tax. Why'd you read all this other stuff? Why do all these, oh, he'll murder me. Roger Taney, John Marshall, John Roberts, why do they write all this stuff in a case in which they have no power to do it? He'll murder me if I ever heard me say this. Right. Yeah, I've thought about this, right? It often happens that judges decide that they don't have jurisdiction or they don't have the power to do it, but they say lots of stuff anyway. That's a problem, right? I mean, again, I say Marbury should have been a one-page decision. The court lacks jurisdiction, dismissed. Dred Scott. Party A, citizen. Party B, not a citizen. Lack of jurisdiction. Dismissed. But that's not what they wanted to do here. Chief Justice Taney. I have a picture of him. Chief Justice Taney decided that this issue of slavery, where is it? It was up front. That this issue of slavery had to be resolved nationally, right? That we could not have this sort of. I have a picture of Taney. Where is it? There it is, right? That Chief Justice Taney decided that this issue of slavery had to be resolved. That we couldn't have this sort of sectional conflict going on any longer. And who would resolve this conflict? Not Congress, not the president, but the Supreme Court. All right. He made a judgment that proved to be. There he is. There he is. This was him later in life. Don't laugh. I mean, it's a photograph, right? But there's a great quote. Let me find the Scalia quote. Scalia had this great quote in a case, and I'll read it to you. He says, there's a portrait of Justice Taney painted in his 82nd year, which is about how old he is here. He's sitting there all in black in a red armchair, almost lifelessly. He just stares straight out. This is Scalia. And Scalia writes, there seems to be on his face and his eyes an expression of profound sadness and disillusionment. Perhaps he always looked that way, even when dwelling upon his happiest thoughts. But those of us who know how the luster of his great Chief Justiceship came to be eclipsed by Dred Scott cannot help believing that he had the case burning on his mind. Years earlier, he thought he was calling the nation together to end this controversy, but he did not. Instead, I'm just paraphrasing, the court prolonged and intensified the anguish. So Scalia, who went to Harvard, probably looked at this portrait of Justice Taney all the time and just saw this sadness in his face of a man who thought he could solve the nation's problems with opinion, and he utterly, completely failed. So to Angelica's point, you're right. You were correct. This could have been a one-page dismissal for lack of subject matter jurisdiction. No question about this, right? but he wanted to decide this issue. And he drew every possible inference in favor of slavery. Every inference. His opinion was so long that basically the clerk had to say, we have to cut this down, right? If the only issue here was about diversity jurisdiction, why would he need to declare the Missouri Compromise unconstitutional in a case with no jurisdiction? He wanted every facet to be settled in this case. And I can tell you with the benefit of hindsight, he did not succeed. This is a decision that's looked upon as one of the worst of all time. Statues of Roger Taney have been taken down. In fact, the Maryland State House, where he was a prominent Baltimore citizen, very famous Marylander. There was a statue of him in the state capitol in Annapolis. I've seen it. Oh, I can't see it anymore. They took it down in the dark of night. They had a flatbed and a pickup, the crane things come in the middle of the night, and it took when nobody was looking. People have been pouring red paint on it for some time. There was one in Carroll County, Maryland, if memory serves. That's where he was from. They're pouring paint over it. By the way, the Taney bust is still at the U.S. Supreme Court. I wrote years ago if they're going to take it down, maybe for John Roberts' dead body, but it's still there at the Supreme Court. By the way, I actually don't favor taking down statue. I think you should keep it there and remember why they're there. I think it's actually a better lesson to say at one point this is a person who we were respecting. I think taking the statue ignores the history. It's almost erasing. I'm actually not a fan of taking that statue. I think it actually is counterproductive, but that's my rant. I'm sorry. But yeah, his statue's been taken down across the country to different places. And you look at that photograph or look at his portrait, and you just see this lifeless look like, man. And by the way, he was a smart judge. I don't want to. He had a lot of very important opinions over the years, Merriam and others, just very important decisions. So his life did become eclipsed by the Dred Scott decision, without question. All right, let's actually walk through this case. I got an hour of wind-up. Let's actually do the case. Okay, Shreya, are you next? Yes, ma'am. Oh, someone's missing. Who's? Yeah, okay. I was one of them off. Okay. And please sign to the attendance, please, if you haven't already. I don't know if I have any questions today. So, I didn't start the class. No one told me.
Oh, no.
No one told me. I was what? I was cooking with gas, man. All right. You know what? I'll accept that. When I'm cooking, you gotta let me cook. No notes. It's all just in here. Yeah. The only thing I check notes like the dates. I don't remember the dates of things. Let me shoot it off by a year or two. All right, let's cook. Shreya, let's cook. All right, so can you give me the facts, please, in Dred Scott against Sandford? And by the way, it's this quirk. If you look at the case that's reported, it's Sandford with a D, but the guy's name was actually Sanford, S-A-N-F. So there was a glitch on this. Actually, Professor Nelson wrote an article on whether it was Sandford or Stanford, and we're never sure on that. But anyway, the guy's name was Sandford. Go ahead, Shreya, just give the facts, please, of this case.
So this case had Dred Scott and his wife Harriet, who were both enslaved, and their owner took them around for immigrants from Missouri to a U.S. Army port in the Free Wisconsin Territory.
Correct.
And then the Free State of Illinois. And after his wife Harriet Dred asked a Missouri State court to declare that his family was emancipated because of their presence in the Free Territory. And initially Scott won that case because at the time Missouri case law said that a slave was emancipated if they traveled to a free territory or state, but then the Missouri Supreme Court reversed that precedent.
Okay, very good. Let me pause you there. Thank you, Shreya. So this was a case that was all too common, right? We had these Southerners who owned slaves, and they traveled. The master in this case was actually a physician, a doctor who traveled to various military bases in the territories, and he brought Dred and Harriet Scott with him. They were a couple that were allowed to marry. By the way, they needed permission to be married. If you notice, that was in the case. They had permission to be married, and they were allowed to be married. They were brought up north. Several of their children were born up north. In fact, can you imagine being born on a boat? That just sounds awful. Can you imagine giving birth on a boat? I mean, just it's sort of tough to even think about. When they were emancipated, when they brought up north, they went back down to Missouri. and they sought what was called emancipation. And they argue that under the law in effect at the time, that Missouri followed the Somerset Rule. And by the Somerset Rule, I mean they would be emancipated upon stepping foot on free soil. That as soon as they stepped foot, they were there. The lower court, following the precedent of the state, ruled that in fact they were emancipated upon setting foot in the free soil. And again, it was both a free territory and a free state. There were two free soils they stepped onto. But the case was appealed to the Missouri Supreme Court. And the Missouri Supreme Court ruled, never mind, we're changing our precedent. We're not following the Somerset Rule. You are not emancipated. You are still a slave. And to be clear, when the court reverses its precedent, it's pretty clear why, right? They did not want to allow their own slaves to be freed. It was pretty clear what happened. Now, could Dred Scott have appealed that decision from the state Supreme Court to the U.S. Supreme Court? He didn't. It's not clear he could have, and the reason why it may not be obvious to the students, you can only appeal a case to the Supreme Court if there's a federal question presented. I'm not sure what the federal issue would be. I mean, there really probably wasn't one. I mean, perhaps because he went to a federal territory. I'm not sure. Again, this was not like a case where there was diversity jurisdiction. There's not what's called maybe an adequate independent federal ground. Maybe there was, I'm not sure. I go back and forth on this question. But for whatever reason, Dred Scott did not seek a review in the U.S. Supreme Court. Instead, he tried a different route. Right? Name, sorry. Taylor. That's okay, Taylor. Thank you. Taylor, where did Dred Scott file his suit after he lost in the Missouri Supreme Court? He did not start in the U.S. Supreme Court. No, he did not. Where did he file suit? This is the important part of the case. Alexandra?
Wasn't it a federal court?
Federal, which kind of court?
Federal district?
Yes, ma'am. And how did he assert jurisdiction to get to federal district court?
Didn't he say he was a citizen of Missouri?
And who is he suing? Who is the defendant?
He was suing Sandford.
Where did Sandford live?
New York.
Correct. So this is, what might seem as a routine diversity case, right? You had a citizen of Missouri suing a citizen of New York in federal court in Missouri, right? This happens all the time. Except, wasn't the issue whether Dred Scott was a citizen? Wasn't that the issue? Huh. So the case goes to the Supreme Court to decide a very simple question. Was Dred Scott a citizen for purposes of diversity jurisdiction? But the court uses this moment to go way, 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 way out and decide a lot of issues. So let me just say at the outset, I don't know, to be honest with you, for purpose of diversity jurisdiction, if Scott was a citizen. It's actually a question that people don't want to talk about. I'd like to think the answer was yes, but under a state law, he wasn't a citizen. There was no federal definition of citizenship. I don't know. I'm not sure. It could have been there just wasn't diversity jurisdiction here. I don't know, actually. But that's like a fairly small question that it's dwarfed by everything else that happens afterwards. Instead, Tawney decides whether a person of African descent could ever become a citizen. What does he say to that question? He says no. So it's not whether maybe under state law they're a citizen, maybe they're not, right? That's a question that we can actually talk about. He's saying that you could never become a citizen. Now, how does he make this case? What does he argue to make this case?
He bases it based off like what the founders thought of like their views on he goes back to like the Constitution and the Declaration of Independence and kind of puts himself in their place of how they saw slaves and African Americans and that they would never thought consider them as citizens.
Yeah. And what he basically does, and I think your answer was correct, what he basically does is look at the Declaration of Independence. Look at the Constitution's text. If we say that all men are created equal, and we know they're not equal, then they really can't be people. If we say that all people have this life, liberty, and property, right, and they're not getting it, that means they're not people. In order to make the case that they cannot be citizens, he has to dehumanize them in every sense of the word. Because if they have any of these rights, then he's wrong. Tawny can only be right if these are chattels, if these are a mere article of commerce. If he's wrong about any of those things, then he's wrong. So he has to go, this is why I'm trying to convey to you, he has to go out of his way to make all these extremely aggressive arguments about citizenship to ensure that he is right, he cannot be proven wrong. He says they were not intended to be included in the word citizens, and they cannot claim them. And there's some language in here that's pretty awful. He says this was a subordinate and inferior class of beings who've been subjugated by the dominant race, and whether emancipated or not, remained subject to their authority, and had no rights or privileges but such as those who held power and the government might choose to grant them. What he's saying that even if you're emancipated by a state, you are still not a citizen of the United States for purposes of federal law. The states can do whatever they want. That's their business, right? They want to give you rights, that's up to them. But you are not, under our Constitution, given those same rights. And he creates this distinction which didn't really exist before between national citizenship and state citizenship, right? That wasn't a concept that was well understood. It was understood that if you were a citizen of one, you're a citizen of both. That's how a lot of people saw it. But he said, no, these are different concepts. Even if you're a citizen under your state, he puts actually in quotation marks, like scare quotes, right? You're not a citizen under the Constitution. Only Congress can decide the national law, the naturalization laws, of how you become a citizen. And he goes back to the Privileges or Immunities Clause in Article 4. Where is it? Yeah, over here. This one. And he really says, if the states can grant citizenship, does that mean that a person traveling from one state to another gets all these rights? That can't be right. We could not allow entire populations from the north to come south and bring with them all these rights. Does traveling to a free state clothe them with all the privileges and raise to a rank of citizen? No. If a person goes from Missouri to Illinois, do they get all these rights that Illinois people have? Illinoisans? What do you call it? I don't even know. People, Illinoisans? If a person goes from Missouri to Illinois, do you have the rights all that Illinois people have? He said that cannot be right. He says the Constitution was adopted for the dominant race. Slaves were allowed when the Constitution was adopted. He then has language. He says this is an inferior order, an unfortunate race who's bought and sold as commerce. Yeah.
I don't understand, like, so if his goal with this case is to settle the whole issue, why not just say that, like, I don't know, I don't know how in his mind this would have settled the issue, or, like, prevent post-time.
Well, let me ask you, why do you think he did all this then? I mean, he believed it, no question, he believed it. That's an easy one, but you don't put everything you believe in opinion. Why do you, right? I mean, sometimes you have you write stuff on a piece of paper, you shove it in a drawer, right? Why do you think he did all this? He was being prodded by President Buchanan. President Buchanan was actually lobbying and said, look, Roger, you got to write this opinion to clean this issue up for us. you'd make it clear that there's an ideology. By the way, I make this point as well. In the years between ratification and the Civil War, a pro-slavery ideology evolved, and this is sort of hard to grasp. By the way, do you know why there's a Southern Baptist church?
Because they love slavery. They want their own church.
Right. Any Southern Baptist church, I'm sorry, but it's true. It's history. The Baptist church schismed, right, because of the slavery issue. The Northern Baptists were abolitionists, and the Southern Baptists were not. And they actually developed an ideology. This was actually grounded in Scripture, that it's an act of compassion to actually have slaves, that they're not subject to wages. You're actually caring for them from cradle to grave. There was an entire ideology that emerged to make this not just something that can be tolerated, but actually a morally justified, a positive good. And this is sort of the ideology that Tawney is articulating about this inferior, unfortunate race. Yes?
So why couldn't Connie just find, like, I don't know enough about the Constitution to say, like, but maybe some form of interpretation for further territories or for future territories as far as the ways, like, what was there just so much pressure to establish that?
He wanted to make this clean, right? By the way, so we know the 13th Amendment is actually prohibiting slavery, but that wasn't the only one. There was actually an amendment called the Corwin Amendment, C-O-R-W-I-N, the Corwin Amendment, C-O-R-W-I-N. It was a proposed 13th Amendment that said slavery shall never be abolished. Before the Civil War, that amendment said that slavery will always be here. That didn't pass. Tawney was doing basically that by saying slavery today, slavery tomorrow, slavery forever. That this is what the Constitution allows. Right? Again, it's easy with us to oh yeah, it's the North of the Civil War, right? All that stuff's, we know that history. But no one at the time knew which way this conflict would go. It wasn't known. And Tawney put his bets on the South prevailing. Other questions we have? Intense lecture, I know. Not like this, like, growing marijuana in your backyard and, driving minimum drinking age, right? All the stupid things like, oh yeah, who cares? Yeah, Polina.
So, initially, didn't the framers have the idea that if you were a citizen of the state, then you were a citizen of the nation? I mean, the framers weren't born here, so I thought that having that ideology established in the Constitution, then in a way, citizenship was defined.
Well, I agree with the first thing you said, but not the second thing you said. So the framers absolutely consider the fact that they were not born here, right? So let me just go to this clause. That's right. This is the clause about who can be president. I thought maybe a little bigger so people can see it. It says, no person except a natural-born citizen or, Paulina, a citizen at the time of the adoption of the Constitution should be the president. That's the Alexander Hamilton clause, because he was born in the Indies. He was not born in the United Colonies. So it said, you get one time at this, right? Either you're born in the United States, or if you were still alive when the Constitution was ratified and you were a citizen, you become a president. This is the closest you get in the Constitution to saying who a citizen is. You also have, though, Congress the power over naturalization, which is something that Tawney does talk about, right? Congress the power to establish uniform rules of naturalization. So Congress had ways of becoming a citizen from the beginning, but it was by statute, right? Congress had to approve it. The Constitution itself doesn't say what it means to be a citizen. That would come with the 14th Amendment later. People argued about it. And when you say the framers thought this, framers thought that, there were a lot of framers, and they thought lots of different things. And this is sort of the point that Frederick Douglass articulates. Is we don't really know what they all thought in their heads. We do know the words they chose. You seem unsatisfied with my answer. No, tell me more. I'm happy to answer more. If you have more later, I can ask, okay? What other questions you have? I appreciate you guys are handling this pretty well. This is not an easy class teacher. I prepared a lot yesterday. Hopefully it's working, I think. Am I cooking? He's not here. I think I'm cooking okay. But there's a problem for Judge Tawney. Right? What's the problem for Judge Tawney? He's making historical claims. about how free blacks were treated when the Constitution was adopted. Those claims can be tested. So Ryan, is it the case that all of the states treated their black residents as slaves?
No.
Could some of them vote?
Yes.
Could some of them have citizenship rights?
Yes.
Could they own property and serve on juries and buy and sell, make contracts? Yeah. So the dissent from Justice Curtis thing is significant. Again, the vote here was not 5-4 or 7-2. But the two dissents, I think, were fairly significant. Okay, why? So Justice Curtis says, Tawney, you're wrong about the history, right? Tawney's making what you might call an originalist argument. Like, here's the practice when the Constitution was ratified. But he's simply wrong about that. About half the states allowed black citizens to vote. They had the most essential of the political rights. They could serve on juries. They could buy and sell property. They had free speech rights. They could bear arms. They served in the Revolutionary War. You better believe they did, right? So he's simply wrong about the history. So it's often argued that if you are sort of an originalist, you support Dred Scott, which I think is a slander of an argument, but it's actually not even correct because Tawney made the history up. He offered what we might call a sanitized view of history, maybe put that charitably. He offered a version of history that was skewed in one direction, where he only listed stuff that sort of helped his case, and he omitted the stuff that maybe cuts the other way. And judges do this all the time. Don't get me wrong, judges do this all the time. But when you have a dissent calling you out on it, I think it's significant. Justice Curtis says that free people of color were citizens of some of the states, and they had these rights under the Constitution. He says the Constitution speaks of we the people, not we the white people. That the language chosen has an effect. Okay? Now, one thing interesting to note, Justice Curtis was so disgusted by Dred Scott that he resigned from the Supreme Court after this. He resigned. He stepped in and was like, screw this. I'm not doing this anymore. That's what you call a noisy withdrawal. Right? You ever heard the phrase noisy withdrawal? When you resign from the Supreme Court because you're so sick of an opinion? Yeah. There was another dissent from Justice Nelson, Justice McLean. Nelson concurred. From Justice McLean, who talked about Somerset. And he said that the Constitution was not made for any one race. Okay. I think I did enough of the opinion stuff. I got a lot of other stuff to talk about. What questions you have? The opinion itself is actually straightforward, right? Straightforward is the wrong word, but the actual legal issue is not that complicated. Sean, is he here?
Yes.
Yes, sir.
So Justice Tawney made an argument about a state citizenship as essentially a federal government citizenship, which I was unconvinced by, and then Justice Curtis brought up that there was no provision about general citizenship, and so I mean I see how you finagle his way, but what do you make of the like?
Right. So again, if you just go through the Constitution on some of these provisions up here, it speaks to the citizens of each state. Right? It doesn't say state citizens. It says citizens in your state. Okay. If you look at we're going to talk to where is it? Right. It speaks of citizens of each state, citizens in the several states, citizens of different states, blah, 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 citizen of the United States, citizen of the United States, a citizen of the United States, and so on. As I read the original Constitution, I think Judge Curtis reads it the same way, there wasn't this sort of distinction between federal citizenship and state citizenship. There was just, you were a citizen of the United States, and there are 13 states in that union, and those are your states, right? It was probably true that only Congress could grant citizenship to their states. That's probably true, because Congress has the power of naturalization. But I think it was certainly the case that Congress did not govern what we would today call a natural-born citizen. And this is perhaps coming to a contemporary debate, right? What is natural-born citizenship, right? There's an issue that we're all sort of talking about now. But I don't think there was much of a difference between federal and state citizenship. Let me just prove Sheldon's point to you in a moment. If you go down to the 14th Amendment, Section 1, I'll come to this later. All persons born or naturalized in the United States and subject to the jurisdiction thereof, the part matters, are citizens of the United States and of the state they reside. Both. 2 for 1. This sentence reversed Dred Scott. It didn't say it, but you better believe it did. This one sentence, to Shelton's point, right, reversed Dred Scott. If you're born here and you're subject to the jurisdiction, or you're naturalized, you are now a citizen of both your state and your country. You can't have this sort of bifurcation where you're a citizen of New York but not the United States. We don't have that anymore. But arguably, did you need an amendment to do that? Or is Tawny simply wrong? I think the issue was silent on this issue. I think the better answer is that there was not this bifurcation, but here it's clear. What are the questions you have on Dred Scott? I have a lot of stuff I want to talk about as well, but I want to answer your questions first. Yes, sir.
So the part where he, I guess, declared the Missouri Compromise
Yeah,
unconstitutional,
yeah.
that would fall into that substantive due process?
Yes, sir. Yeah, he basically said that the Missouri Compromise violates the Fifth Amendment. That to deprive a person of their property when they come into a northern territory violates the Fifth Amendment. And so basically the entire compromise is unconstitutional. This is not in your book, but he also argues that Congress lacks the power to permit slavery in the territories. It's sort of less important because he also went to Illinois, which is a free state. Home of Lincoln, by the way. Yeah, a follow-up question? Shelton?
So is there an argument that Justice Tawny's opinion is invalid because he had no jurisdiction to have a conclusion?
That's what I say about Marbury. I think Marbury was. I don't think Marbury is valid. But yeah, well, let's talk about this for a minute, right? So what do you do, right? I think these are my questions for on my list today. I won't get to any of these, I don't think. Question 4. Ooh, let's ask this one. It's in the news today, isn't it? Oh, we want to talk about people on airplanes. Look at Archer Tawney for a bit. Trenderagua, right? Was the Lincoln administration, question 4, bound to adhere to Chief Justice Tawney's opinion about citizenship in Dred Scott? Yes or no? Answer carefully. Think about this one for a little bit. Don't just click. Think about this one. Yeah. All right. You're raising your hand. Don't fight the question, please. Don't. I know what you're gonna do. Just I'll call on you in a minute, but don't fight the hypo. No, you asked for it. All right. Let's see what we got. Ooh. No, 80%, 80-20 rule. Look at that. All right, Stephen. How are you going to fight my hypo?
I was just asking if this is after the Civil War. I put yes.
Well, Lincoln wasn't alive after the Civil War finished, so that's a hard question.
When it was happening, I guess. Whenever
Nope. This is right after the case was decided, 1860.
I mean, still it's yes, I think.
Okay, yeah.
I put no because Civ Pro, the res judicata, I think, or whatever it was, is like only the parties to the case are bound.
Ooh.
Nice.
everything Civ Pro is Commonwealth. Don't forget that. We came first. All right. Who here put no on to defend it? Yeah, Fidel.
I would know because I asked you this question, you said that they don't have to adhere to it. It's just basically they just state their opinion. They're not bound by Supreme Court opinions.
Well, is that because who just said there's no jurisdiction? Johnson and Mimico? Can the president say, you know what? I think the court lacked jurisdiction. I'm not going to follow it? Technically, what's it technically?
Didn't you say that the Supreme Court doesn't have any real power unless someone actually enforces it?
Well, I did say that, but does that mean they're not bound by it? Can they just if there's a plane flying to Venezuela, they say, oh, it's going to let it, or El Salvador, just let it keep flying? What?
I thought you told me they could do that.
You do lots of things with an article too. What else? I do lots of things. Yeah.
Oh, and also, President Johnson did whatever he wanted when he just said the rule that Congress had was he wasn't going to follow it, and that was alright. So.
With the firing of the officer, right?
Yeah.
The statute said the president can't fire the Secretary of War. He fired him anyway. Just this past month, President Trump fired a bunch of people that said he can't be fired. Oh, you're uncomfortable. Conrad, help! Please bring us back, Conrad. Not gonna happen.
Isn't the whole thing about when you say bound, I'm thinking binding.
Ooh,
and
res judicata.
yeah, and I'm like, well, a lot of that certainly would be considered dicta and persuasive. So.
Ooh. So can I tell you? Yeah, Addie, go ahead.
It's an advisory opinion.
It's an advisory opinion. So let me tell you what actually happened. After the Civil War, Abraham Lincoln, after he was dead after the Civil War, after Dred Scott was decided, there was a young lawyer named Abraham Lincoln. He had served in Congress, and he was running for Senate in Illinois. And he made his political platform in large part opposing the Dred Scott decision. I mean, you may not know this, but the Republican Party was born in opposition to slavery. Right? This was like the basis of the Republican Party, which Lincoln was a leader of. And here's what Lincoln argued. Lincoln argued, Dred Scott v. Sandford, res judicata. Who is bound by the decision? Dred Scott and Mr. Sandford. No one else. Was the United States a party to that case? No. Was the United States asked to defend the constitutionality of the Missouri Compromise? No. Was the government there to say that, no, our thing's constitutional? No. Taney was issuing decisions by parties who were not present. You want to see how messed up the ruling was? There was no government lawyer saying, we have this compromise, it's constitutional. He just decided on his own. In a case about civil procedure professors, a boring case about jurisdiction, he decided that the entire Missouri Compromise was unconstitutional. You don't do that. So Lincoln said, fine, you know what, Mr. Taney, you made your ruling. Doesn't apply to me as the U.S. president. I'm not going to follow it. So what did Lincoln do? I'll tell you exactly what he did. He granted passports to free blacks. The quintessential act of citizenship is giving you a passport to travel abroad. How did Douglas get to England, right? Right? He went to England before. I'm sorry, I'm off on chronology. But Lincoln granted passports to free blacks. He allowed free blacks to join the Union Army and grant them citizenship if they joined the Union Army. He did all these things for his administration that were inconsistent with Dred Scott. And you think, yay, yay, rah, rah, go Abe, right? Go Lincoln, right? Well, wait till a president you don't like does something in contrast to the court. Just hold on to that one, right? Just hold that thought for a day or two. What goes around comes around, my friends. During the Reconstruction, during the Civil Rights era, you had a decision called Brown versus Board of Education. You all heard of him, I'm sure. Who was Brown? She was a little girl, wanted to go to school. Who was Board of Education? It was Topeka, Kansas, Board of Ed. What about a school in Virginia that wasn't part of that case? Were they bound by it? No, they didn't follow it. Schools in Little Rock, Arkansas, were they bound by Brown? No, they weren't part of that either. The mere fact the Supreme Court says something does not make it God. Right? They are not God. They can't make everything everywhere change it. This is the point I'm making to Fidel a minute ago. They can't. They can only issue judgments for the binding parties. What happens if a federal judge in D.C. orders a plane somewhere with a Gulf of whatever you want to call it to turn around, right? the limits of judicial power become very clear in controversies like this. We're not talking about mundane, I love res judicata as much as the next guy, but this is not about, sort of a breach of contract dispute about whether people are bound by it. These are issues, the nation's on the brink of war, and we're arguing about judgments and binding. Now, Tawney thought, he actually believed this, he wrote this, that this opinion would prevent a civil war. He was wrong. It's hard to see a judge being more wrong about something ever in the history of the world. I mean, it's got to be up there top 10, I'm sure. But a judge actually thought that you could avert a war based on a judicial decision. I think it reeks of hubris, a judicial arrogance. But he believed it. So what happened in the wake of this? So again, Lincoln lost the Senate race in 1858, but then he ran for president in 1860. And at the time, there was a four-way race for president. Lincoln became president without winning a single southern state. And the election of 1860 more or less led to the Civil War. By the time you had the inauguration, a number of states had seceded. And by the way, who issued the oath of office to Lincoln? Tawney. You think the Trump-Roberts exchange was a little bit awkward? Imagine the Lincoln-Tawney inauguration. I would like to have been there for that one. It's like, hey Roger, what's up? Right? Remember me? Because by that point, the Civil War had basically already begun. By the time Lincoln was inaugurated in March of 1861. And again, Lincoln had made his campaign saying, do not follow what this guy wrote. And yet you have their Tawney issuing the oath of office. Might be a little bit awkward, huh? See, Robert's like, oh man, I sat your impeachment trial, now you're president again. Well, look at this, right? Nothing's new under the sun. So what follows is a bloody and gruesome civil war. The issue of Dred Scott was not resolved in a courtroom. It was resolved on a battlefield. And whatever you want to say about the Civil War, whichever side wins would decide the slavery issue. That was kind of what's going to happen. As history dictates, the northern side prevailed. And in the wake of the Civil War, and even before the war ended, it became clear that we would need to change the Constitution. Right? The Constitution had to be changed. If Roger Tawney could read the Constitution to justify a decision like the Dred Scott decision, that the Constitution itself had to be changed. And several amendments were proposed in fairly rapid order. Did anyone see the movie Lincoln with Daniel Day-Lewis? I actually didn't like it, and maybe I could talk about it before I later, but it was a good movie. I didn't enjoy it. But the premise of the movie is Lincoln pushing for the ratification of the 13th Amendment. This was one of his last acts. He died shortly after this was approved. And the 13th Amendment was to nullify Dred Scott. Right? Dred Scott says the Constitution approves of slavery. Dred Scott says that deprive people of the right to slavery violates the Fifth Amendment. No more. And Section 1 of the 13th Amendment says, neither slavery nor involuntary servitude, except as punishment of a crime, shall exist within the United States or any place subject to their jurisdiction. There's a lot going on there. So first off, neither slavery nor involuntary servitude. You might ask, Josh, what's the difference between slavery and involuntary servitude? Aren't those the same thing? We'll study this later, but I'll just give you a preview now. Arguably, slavery is broader. It was an institution of control. It wasn't just merely putting a person in chains and shackles, but it was something broader of what is slavery. And we'll talk about that later, what that means. And this isn't just a limitation on government. Up until this point, the Constitution acted upon the government. Congress can't do this, the states can't do this, and so on, right? But here, this is a limit not just on the government, but on private citizens. No one could hold a slave. Shall exist, it cannot exist. Private citizens could not hold slaves. It shall not exist anywhere in the United States. And even if you're not in the United States, the rule applies there as well. Yes, sir.
I'm just kind of thinking about, nowadays and how they'll have prisoners be.
Oh yeah, you want to talk about that one? Okay, let's talk about that one. Yeah, this being an issue. You ever see the Oh Brother Where Art Thou, the chain gangs, right? So look, just pause for a minute. If you're in jail, is that involuntary servitude? Are you there against your will? Yeah, you kind of are, right? So they had to put this in there, right? They had to at least acknowledge that people who are incarcerated will be involuntarily held upon conviction. But you better believe that in the wake of the Reconstruction era, southern states started manufacturing all these crimes, vagrancy, loitering, other things, just kind of get people arrested. Say, oh, you're convicted of a crime, we can hold you basically in bondage. So this part became basically a backdoor to slavery. I don't know, we don't have it's not in the book anymore. If it is, I don't teach it. But there were actually cases of holding these bogus crimes like loitering or failing to failing to work. Being unemployed was a crime, and basically be arrested for not working. They made up all these dumb crimes to get people locked up, and they would just enslave them. You're shaking your head, but this happened. Yeah. All right, but thank you for the question. Yeah, I skipped over that part. Should have mentioned that part, but yeah, that's in there.
Yeah,
But
it's terrible.
but
And, like people now, when they work for 30 cents an hour, it's like.
well, why do you think prisoners are not subject to the minimum wage? It's actually because of the 13th Amendment. They're not obligated to have that. I want to go to the part 2, section 2, if I can. Section 2 is what's called the enforcement clause. The enforcement clause. And section 2 gave Congress the power to enforce section 1. They could enforce section 1. And section 2 gave Congress this authority that was very significant. Why? Today we think of the Constitution as enforced by the courts. That's just a myth. That's a circled myth. The primary driver for the 14th Amendment was the Congress. The Congress wanted to be in charge of enforcing this amendment. Okay? The Congress was going to be in charge of enforcing this amendment. So what did Congress do with this? They passed a series of laws. The Freedmen's Bureau Act. Right? The Civil Rights Act of 1865. They passed all these laws that gave rights, the rights of citizenship, the rights of free speech, the right to own property, the right to bear arms, right? They passed all these statutes to grant rights to the freedmen. When I say freedmen, I mean the freed slaves, but that's what they call them, the freedmen. And know what happened? President Johnson, remember Johnson? We just mentioned Johnson. He vetoed these bills. So Congress is passing all these Reconstruction Acts, and he vetoed them. By the way, when I say Reconstruction, I mean they're trying to rebuild the South. They're reconstructing it from the. Imagine if you demolish a stadium and build it from the ground up. They're trying to reconstruct the South. One of the reasons why he was impeached, by the way, Stephen, also was basically vetoing all these acts. That he's frustrating the act of Reconstruction, because Johnson was a Tennessee Democrat who did not favor Reconstruction. He was like, all right, we need to move on. Move on, guys. Bygone be got bygones, right? Johnson issued an amnesty to all the Confederates. You think the J6 pardon was controversial? On Christmas Day, President Johnson pardoned all the former Confederates. All of them. Not all of them, but most of them. All right. So, again, Congress passes all these bills. Johnson vetoes them, but then the Republicans and the majorities override the veto. But this created a fear. What was the fear? The fear was that some future court might say these civil rights acts were unconstitutional. So then Congress then enacts the 14th Amendment in 1868. There's so much stuff in the 14th Amendment, it's hard to cover, but I'll try a high-level overview. We'll cover more next week. But the point I want to convey is that this provision nullified Dred Scott. The Supreme Court never ruled Dred Scott. If you go there as a red flag, maybe, it's not from the court, it's from Congress. Citizenship clause. It says, all persons born or naturalized in the United States, persons, and subject to the jurisdiction thereof, are citizens of the United States and of the state wherein they reside. This gets rid of this sort of artificial distinction between national citizenship and state citizenship, right? If you're one, you're the other. You are a citizen of your state. And you are a citizen of the nation. Yes?
If I'm not mistaken, we also have a due process clause in the Fifth Amendment.
But
right?
which branch of government does it apply to?
Uh,
Barron v. Baltimore, my friend.
what'd you say?
Barron v. Baltimore. What's Barron v. Baltimore about?
Oh, the takings? Right?
Kind of, but more importantly,
It was in Maryland, wasn't applied, the Fifth Amendment didn't apply to Maryland.
correct. Did the Bill of Rights apply to the states?
Oh.
Oh, yeah.
Okay,
So you're right.
Yeah.
There's a due process clause of the Fifth Amendment, as there's a taking clause of the Fifth Amendment, that only limits federal power. Okay, but let me continue if I may. So we have the 14th Amendment. Section 1 has a citizenship clause. Then continues with what's called the Privileges or Immunities Clause. The Privileges or Immunities Clause. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. If you remember, the Article 4 clause said that a traveling citizen has all the privileges of people of their own state. Right? If I go to New Jersey, I get all the rights that New Jersey people have. Right? But it doesn't say what rights New Jersey citizens must have. This clause says that no state shall abridge any law that violates the privileges of citizens of the United States. That there's this category of people called citizens of the United States, and they have these rights, and no state can violate those rights. This was considered the most important part of the amendment, that states cannot deprive their citizens of these rights. Whatever these rights are, states cannot deprive you of them. This was very important. What were these rights? Did these rights include the provisions of the Bill of Rights, speech, religion, arms, and so on? Were there other rights, natural rights, unenumerated rights? What are these rights? If anyone did the reading for Wednesday, we'll do the slaughterhouse cases. You'll see the answer is not very many rights at all. Yeah. Then we get to number 3, the due process clause. This is what I think Michael asked me about a moment ago. That the states, not just the feds, the states cannot deprive you of life, liberty, or property without due process of law. The states can't do it either. To this point, only the federal government was subject to this restriction. Now the states are subject to it as well. Does that clear up, Michael?
It does, and this is the one that they were. I mean, they didn't base the holding in it in Hearts of Atlanta, but this is the one they were talking about, right? This
We'll get to section 5 in a bit. I will talk about that in like 2 minutes, I promise.
Oh, sweet.
You're almost on track. Okay? Right? Almost there. So then we have the due process clause. That's number 3. Number 4 is the equal protection clause. This is the one that we'll talk a lot about this semester. States cannot deny to any person within its jurisdiction the equal protection of the laws. So under the modern doctrine, what this seems to mean is that we cannot classify people differently. You can't have one set of rules for white people, another set of rules for black people. Or you can't have one set of rules for women, another set of rules for men, right? It's about equality of treatment. But that's actually not what it says. It says protection of the laws. Let me ask you a question. Does the government have a duty to protect you? Let's say that there's a young child and there's all these allegations that the parent's abusing the child. And the government fails to protect the child from that abuse. Can you sue the government for failing to protect the child? The answer is no. There's a case called DeShaney versus County of Winnebago. Actually, it was, the kid's name was Young Joshua, or poor young Joshua, as Justice Blackmun said. Actually, funny, Justice Blackmun, yeah. But the short answer is, under modern doctrine, you have no right of protection from the government. If the government fails to protect you, that's just too bad. Go talk to your member of the state legislature. Go talk to your member of city council. That may not be correct as an original matter. In fact, one of the key sort of drivers of this was protection, meant literally protection from what? The Klan, lynch mobs, go down the list. That the state had to protect you from violence. It often happened that you had the Ku Klux Klan lynching people, and the government said, "Oh, well, look the other way, right?" Or in fact, they just put a hood on and joined the show, right? So this was actually about protecting people from violence. there's a lot of stuff that we've deviated far from where the original meaning was, and this is one that I think is a case. Professor Chris Green at Mississippi has written about this at length. I think he's convinced me beyond anything that we've completely botched this clause. Okay? But I want to get to what Michael asked me about a minute ago. See, I told you I was getting there, Michael.
Mm-hmm.
Section 5, this is Section 1, the 14th Amendment. There's also Section 5. This is another enforcement clause. And it says, the Congress shall have the power to enforce by appropriate legislation the provisions of this article. What does that mean? Congress can pass civil rights laws to ensure the states are behaving. That if the states are not protecting their citizens from violence, Congress can step in and create Section 1983. You know what that is? The Ku Klux. By the way, Section 1983 is called the Ku Klux Klan Act. Why is it called that? It's to say that you can sue the government without protecting you. That's what Section 1983 is about. It's evolved to other things. Congress enacts laws that prohibit segregation. This was Justice Douglas's point in the Heart of Atlanta case, right? If Congress wants to prohibit segregation, perhaps they can do that with Section 5. We will cover Section 5 later this semester. What you need to know now is that Congress enacts a lot of civil rights laws in the 1860s and 70s, many of which were later declared unconstitutional by the court. But Sections 1 and 5 of the 14th Amendment radically altered the system of government, and they gave a lot of power to Congress to protect the civil rights of the people, and the freedmen in particular. And this was part of the broader effort at Reconstruction. But Reconstruction proved to be perhaps too difficult and became very unpopular. And southern states resisted it. They didn't want to be told sort of what to do. So it sort of came to pass that after President Johnson was in office, you had President Grant. Grant was not a very effective president. And after the Grant administration, by the time we get to the 1870s, Reconstruction was more or less dead, sort of pettered out. And whatever was in the 14th Amendment and 13th Amendment just kind of became a dead letter. And the states were able to erect Jim Crow and other institutions that would exist for almost another 80, 90 years. So sort of the sudden change, the radical change in the 1860s didn't come to fruition. Now, the part of the story that you probably don't know is what role the Supreme Court played in that. The Supreme Court resisted the 14th Amendment. You'll read several cases for next class called the Slaughterhouse case, Brattle v. Illinois, Cruikshank, and others, where the court said, well, you know, if we read these amendments as they're written, it would really change stuff really radically. And we don't think that was sort of the intent, right? We don't think they meant to go quite that far. And there's only a couple years after the Civil War finished. They were alive then. But the court said, no, that's a bit too far. And we get to a case called the Civil Rights case, where Congress passed a law that barred segregation in places of public accommodation. The court said, no, Congress, you can't do that. That's not going to work. We're not going to let that happen. That's too much infringement upon the states and the private rights of people. And you get a case called Plessy against Ferguson, which I'm sure you've all heard of, where the court said, well, you can have separate but equal, and that's okay. And by the time you get to Plessy, basically Reconstruction was dead, right? The enterprise that began with repudiation of Dred Scott sort of went nowhere. And it didn't really recommence until the mid-20th century. All right. I got more stuff, but Michael, you have a question?
No, it's just kind of
Okay. What questions we have? Questions. All right. I want to focus for a bit on the Frederick Douglass readings, which I think are quite eloquent and quite good to read. And he raises this issue that I think is still debated to this day. Is the Constitution pro-slavery or anti-slavery? And he made these arguments in the wake of Dred Scott. And he refers to this infamous decision of the slave-holding wing of the Supreme Court. Oh, good writer. A devilish decision. But Douglas is not sad. He's actually optimistic. He says, "My hopes were never brighter than now." Can you imagine just pause for a minute? He's a former slave. He just read Dred Scott. He's like, you know what? I've never been more optimistic. And I want to just make a point about advocacy, right? There's different ways of convincing people. One is doom and gloom, things are awful, things are terrible. The other one is things are never been better. Optimism sometimes helps to convince. Why? He speaks of a higher power. He says the national conscience is now awakened, that by tawny, this open, glaring, scandalous tissue of lies is now available for everyone to read. In other words, the advantage of a judicial decision is it crystallizes the reasoning, that everyone can see it. Before, people kind of just thought about it, and they had their rumors, and they were kind of thinking about it, but now it's clean, right? You can respond to a decision by the court. And then he says, I love this line, "The Supreme Court of the United States is not the only power in this world. It is very great, but the Supreme Court of the Almighty is greater." Right? The Supreme Court is not final. I guess an appeal to heaven, as it were. Right? But then he actually makes a legal argument that I think is very important. So you probably remember this from contracts, that if a term is not clearly stated in a contract, we generally don't enforce it. And the reason why is this: if there's something very important, we presume the parties would want to negotiate upon it. And if they didn't even mention it, that's a good indication they just didn't think about that part of the contract. So we're not going to imply a term, right? We're not going to apply a term to a contract that's not clearly there. This is what's often called a clear statement rule. A clear statement rule. What does that mean? That if there's some really big issue, we presume that there's some clear statement to that effect, that the statute or the Constitution will clearly address it. Justice Scalia had a very memorable phrase about this. He said, we don't hide elephants in mouse holes, right? What does that mean? If there's some really big issue, some elephant, right, very big thing, we're not going to just sort of mention it indirectly in passing. Here's some things we're going to talk about, whatever, like a sentence here or there. It's going to be big. And Douglas says Dred Scott has to be wrong, right? Because where in the Constitution is slavery talked about? Read it. He says, read it. Tell me, where does that document afford protection for slavery? Where can you find a guarantee of slavery? He says you to read it. Look, it says no person can be deprived of life, liberty, or property without due process of law. That's not slavery. The preamble, we secure the blessings of liberty, Douglas says. That's not slavery. The right to secure in your persons, papers, and effects. That's not slavery. All these clauses strike the root of slavery. And if they're faithfully carried out, there's the important point. If these parts are faithfully carried out, it would put an end to slavery in every state in the Union. So what's he basically saying? The document bans slavery. You guys are just not following it. You guys being hypocrites, right? It's right there, and you're just not doing what the Constitution says. Instead of saying the Constitution's flawed, he says the people who are implementing it are the errors. Their errors, their flaws, how they're doing it. Then he makes a historical point. He says, at the time of the Constitution, people spoke out against slavery. And he quotes from Thomas Jefferson, George Washington, Ben Franklin, Alexander Hamilton, others. And he says they did not hold the views Roger Taney did. He's actually right about this. Right? If you actually read Jefferson and others, they were slaveholders. Don't get me wrong. They were, and worse. But they did not hold the views that Taney ascribed to them. And how does Douglas conclude? He says, my conclusion, I ask for the American people, is live up to the Constitution. Follow the document. Adopt its principles. Imbibe its spirit. Enforce its provisions. And here's this line. I'll read it to you. When this is done, the wounds of my bleeding people will be healed. The chain will no longer rust on their ankles. Their backs would no longer be torn by the bloody lash, and liberty, the glorious birthright of our common humanity, will become the inheritance of all the inhabitants of the highly favored country. So he wrote that in 1857, a couple years before the Civil War. And he lived to see what happened with the Civil War. And it's sort of stunning how much was changed in so little, but then how the sort of the promise he spoke of, frankly, did not come in the 1860s or 70s. All right. What other questions we have? All right. Readings are long for Wednesday, so get started early. I will see you all soon. Thank you very much.